All right, welcome back. Apparently, I've done a bad job of covering Scofield versus Guillard recently. I, I just, I got overloaded with dumb and had to take a break. And frankly, I'm only a couple filings behind, but yeah, it's popping off. So I hate to do this to you, but we're going to have to watch one of Ashley Guillard's videos today. And I really don't like covering her videos. I cover the legal filings. That's what I do. I don't like I believe that she's a clout goblin. She doesn't deserve to have her videos watched. And the only attention she deserves is people exposing her, debunking her, educating based on her. She doesn't deserve attention, especially not positive attention. So I'm going to say, please don't watch her video, except here, because. But I'm covering it. I'm giving commentary on it. I'm even going to educate some. So I have not directly watched the video yet. This is a first impression of the video itself. All I have seen so far is Markie's coverage of the video. Go watch Markie. He does a very good job of it. And spoiler alert, she's threatening to sue people. I don't know that she directly threatens me or not, but I fit in the class of people she's threatening to sue. The only people I know she names specifically, and once again, thanks to Markie for his video, are Markie and Atozy. Now, I'm going to tag Markie and Atozy in the description of this video. So if you aren't familiar with them, go subscribe. They're great. They do good commentary. They're not attorneys, but they do good commentary. So I'm going to tag Markie and Atozy, and so if Markie and Atozy watch this video, I realize, at least Atozy has been sued before. It was frivolous and it was dropped because BitBoy Crypto is a little bitch and he thought he'd be able to bully Atozy, but once Atozy raised money for his defense, he dropped it. Well, I'd like Markie and Atozy to know that there is a legal concept that I will cover later in the video that basically, unless they go off the deep end and really defame Ashley Guillard, they've got nothing to worry about. There's a built-in short circuit right away if she tries to sue anyone for defamation over their coverage of this lawsuit. It and it's that defense isn't available quite yet, but it will be very soon. And yeah, it basically makes a 12b6 motion to dismiss for failure to state a claim upon which relief can be granted inevitable. It really does. So, you know, like I said, I haven't watched everyone's coverage of Ashley Guillard. So I can't say that nobody has defamed her. I think I have watched everything that Atozy and Markie have put out, and Emily Baker as well, and Uncivil Law has covered it. Mad Catster, another lawyer, has covered it. I don't think they're shaking in their boots either. But so there might be people out there that have defamed her. They might have said that she's a syphilitic lying cow who has only said what she has about Rebecca Scofield in order to deflect from her theft from her from her Mr. Male mistress. Now, if someone were to say that about her, well, each of those claims would be defamation per se. Now, I'm not saying any of those things about her. Those are all hypothetical. I am not saying any of those things about her, and I would recommend that nobody does say those things about her. But those would all be defamation per se, meaning you don't have to prove damages to win your defamation case, but you still, unless there's a statutory provision, would have to prove damages to collect damages. So either way, saying that Rebecca Scofield is not a murderer, well, that's not defamation. Saying that Ashley Guillard has no factual basis to assert that Rebecca Scofield is a murderer, well, it's not defamation because you're not calling her a liar. You're just saying there's no factual basis. But it still could qualify as opinion, even saying I don't believe there's a factual basis. But even let's say that does count as calling her a liar. Well, because of the concept I'm going to discuss, either after watching her video or in the middle of watching her video, we'll see. But it's not going to matter anyway. So, with that, let's jump in. Apparently, according to Ashley, Rebecca Scofield is hiding discovery. And this video is from the 14th of October. I only found out about it on Saturday because of Markie's video. So this video does not have many views. It's under 1,000. Let's keep it that way. Oh, and by the way, happy Halloween. It's Halloween now. Just after midnight as I'm recording this. But, and also, for those of you who are new, especially since I'm tagging Atozy and Markie, hi, I'm Joe. I'm a lawyer. I'm licensed to practice in Utah. I am not a Texas-based attorney, which might be where Ashley tries to sue people. I'm not an Idaho attorney where Scofield versus Guillard is taking place. But it's in federal court, so the procedures, it's the same. So let's jump into it.
Okay, so I'm going to do an update. I'm going to start doing a daily blog regarding this Scofield versus Gilliard case and situation because I'm looking at these videos. Some of these videos, honestly, I don't really watch them all the way through.
So it's apparently I've been saying her name wrong. Guillard. I assumed double L French, but Guillard.
But they aren't giving out the best information and they don't have the most updated information. So, anyway, the situation that we're in now is we're in the discovery phase, which is supposed to be the phase where, we get to the truth. But here's the issue. Scofield and her attorneys don't want to get to the truth. They just want to continue these lies. The lie that I made stuff up regarding Scofield and that I lied. What did they say? Made false statements knowing they are false. They want to continue these lies that she's innocent and that I just made this stuff up for no reason. Like who would do that? I'm not maybe
You would do that. Now, you may very well be delusional and believe that you're telling the truth. But where is, other than your tarot cards, which courts don't recognize, where is your physical evidence to back up your claim? Where is your eyewitness evidence? Who has told you? Hell, even which spirit told you? That you have no evidence, and you can't survive a motion to dismiss. Well, let me back that up. She couldn't survive the motion to dismiss her counterclaims because they had no factual assertions other than her conclusory statements. And you can't just say, well, let me get into discovery and I believe I will find evidence there to survive a motion to dismiss. But that's not where we are. Her counterclaims already gone. So, spoiler alert for either tomorrow or the next day's video, because we're going to get caught up this week on all the filings. But right now, Professor Scofield has a motion for summary judgment pending. We're waiting on Ashley's response. Well, her opposition, technically. So, she has basically no facts in her favor. So she's trying to get some, and one of those ways we saw way back in the Stone Age, her proposed discovery plan, where she wants all of Professor Scofield's, well, basically everything. In fact, let's find that. I wasn't planning on pulling up any court documents today, but let's find it. Let's find it. All right, now let's switch windows. So she wants from Professor Scofield all social media or other online content, instant messages, emails, text, Word documents, books, or no, those are the things they agree to. Sorry. So Ashley wants from Professor Scofield all devices, systems, servers, databases used by or under the control of Rebecca Scofield. Okay, scope of discovery. That's the stuff we want. She wants the substantial truth of Ashley Guillard's. She wants all information pertaining to the substantial truth of Ashley Guillard's statements about Rebecca Scofield's in the murders, the substantial truth of Ashley Guillard's statements about Professor Scofield's relationship with Kayla Gonsalves, the attorney's lack of due diligence before filing the complaint and failure to abide by Rule 11 of the Federal Rules of Civil Procedure, which is not a cause of action, despite how many times Ashley tried to make it one. The full details of the press release that defamed Ashley Guillard, and all involved, who, what, when, where, why, and any payments related to it. All communication tools used by Professor Scofield personally and professionally to write and communicate with co-conspirators and collaborators in the creative arts, manuscript, and book writing process to resolve the issue of her involvement in the planning of the murder of the 4 University of Idaho victims. All social media accounts created by Professor Scofield and her IP address on TikTok and Facebook to establish her connection to the creation of accounts on social media to continuously harass Ashley Guillard. All communication and financial accounts Professor Scofield used at the University of Idaho to establish a communicative and financial connection to the 4 University of Idaho students. Professor Scofield's personal and business financial records to establish a financial connection to the victims. Professor Scofield's cell phone, tablet, computer, electronic device records to establish a connection to Kaylee and the murders. Communications, documents, emails, personal and business phone records between Professor Scofield and her attorneys pre and post filing of the lawsuit to establish a personal prior relationship between the two prior to the filing of the lawsuit. Well, of course they had communicated before filing the lawsuit. You don't, attorneys don't preemptively file lawsuits and then talk to the client, but she wants attorney-client privileged and attorney work product privileged information. And then she wants all, number 15, all work products between Professor Scofield and her attorneys, which is just insane. She wants all travel documents, arrangements, modes of transportation, rental cars, hotels, and lodging for Rebecca Scofield and immediate family members for the months of October and November 2022 to establish the truth and blah, blah, blah. But then also travel documents, arrangements, and stuff for the past 2 years. And Professor Scofield's alibi for the day prior to, the day of, and the night of, and the next day following the murders. So she wants all this in discovery. The problem is she's not entitled to all of that in discovery. In fact, let's see. Let's see. Well, either way, the Professor Scofield's discovery plan is the plan the court accepted because Ashley's, she wanted so much stuff that she just plain isn't entitled to. And so let's briefly look at why she isn't entitled to it. So this is Rule 26 of the Federal Rules of Civil Procedure, which is the duty to disclose general provisions governing discovery. So this is Rule 26 is where the discovery rules start. In fact, let's see. Rule 25, substitution of parties, 24, intervention. Then we have Title V, disclosures and discovery, starting Rule 26 all the way through to Rule 37. And So okay, we're specifically looking at 26B, discovery scope and limits. Scope in general. Unless otherwise limited by court order, the scope of discovery is as follows. Parties may obtain discovery regarding any non-privileged matter. There goes her attorney-client privileged communications and attorney work product privileged communication or stuff. So any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Information within this scope of discovery need not be admissible in evidence to be discoverable. So, like, you can ask for hearsay information and discovery. You won't be able to present it in trial, but it might lead to things that are admissible in trial. So, yeah, but basically, you can't ask for things that are outside of the party's control or unreasonable for them to get into their control. Now, you can subpoena Facebook, hint, hint, that's something for probably tomorrow, but that might not be allowed because it's her entire Facebook history isn't relevant. So it just, yeah. But let let's go back to the video. But yeah, so the purpose of that tangent was Professor Scofield is not hiding discovery. She is fighting against discovery of things that she believes aren't discoverable, shouldn't be available in discovery. That's not hiding discovery. If the court agrees with her, it'll say Professor Scofield does not need to provide these things. If not, the court will say Professor Scofield is ordered to provide these things in discovery. But that's the entire point of litigation. That for those of you who have followed the other case I just had to take a break from because of the stupid overload, delete laws, filing lawsuits, that's not the hard part. Well, I mean, it is for delete laws because he's never survived a motion for summary judgment or motion to dismiss. He's never, well, I guess maybe in California, the California state case. I haven't been following that one because it's California state case. But discovery is the hard part. It's where so much of the litigation takes place because if you're able to win at discovery, you're probably going to win on the merits in the end. If you're able to get more discovery from the opposition than you have to provide to them, you're at a great advantage. And it's I've quoted the late Representative Dingell of Michigan before, and this isn't going to be an exact quote, but he said something to the effect of, if um, I actually want to find the quote now. Uh, let's see. Okay. So, Representative John Dingell of Michigan, the late representative, said, I will let you write the substance. You let me write the procedure, and I'll screw you every time. Meaning, if you have a better grasp of the rules of procedure, you're at such a huge advantage that you're probably going to win. And as you saw, there's what, 10, 11 rules of procedure. Yeah, 11 rules, 26 through 37 in the Federal Rules of Civil Procedure, plus all the sub rules. You saw scrolling through Rule 26, it had multiple full paragraph sub rules. And then there's the case law on the rules of discovery, the procedure. So you have a better grasp of that, you're going to win. Ashley Guillard doesn't have a grasp of the rules of discovery, which is why she's losing. Well, I mean, also because Professor Scofield has a really good case, but Ashley doesn't have a grasp of the rules of procedure, the rules of discovery. And so she lashes out saying, well, the other side's cheating. The other side's cheating because they're not giving me what I want. But she's not saying why they need to give her what she wants. So let's get back into it. We've only watched 56 seconds so far of this video.
There are people out in the world who would, but that's not what happened. I received I did a tarot reading regarding the murder. I used my gifts, my spiritual gifts, and that's what came out. My information regarding Scofield being the ordering the murder of the four University of Idaho students came that way. It had nothing to do with, I don't even know her. Why would I just make up something about a random stranger?
Because you are a clout goblin. That's why.
But because I'm who I am and she's who she is, people just wanted to simply believe it. One, because they're demonic. And whenever you speak on spirituality, their demons just come out. So, anyway.
I'm a demon? Or I have demons, sorry. Okay.
The issue that I'm having now is that the courts are complicit with what Scofield has going on. So I feel like the judge has done something fraudulent. Here's the thing, either he's like just trying to make friends instead of following the law, one, and something is off with this judge because the court, for example, we're in the discovery process. In the discovery process, they subpoenaed my TikToks. Okay, there was no back and forth regarding that.
It's because your TikToks are specifically where you defamed the professor. So not only are they relevant, the entire case is about your TikToks. Professor Scofield, on the other hand, has, to our knowledge, not made Facebook posts saying, with a selfie saying, look cute, thought I might murder 4 college students today. That's the difference. That's the difference. The court isn't cheating. The court is following the rules. You just don't like the rules. It's It's like playing chess with a pigeon. You know, they're 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 gonna knock over all the pieces, shit on the board, and go home. Ashley is trying to knock over the pieces right now and claim she wins, but that's not how it works.
You sent a letter of intent regarding, they sent a letter of intent saying that they were going to subpoena my TikTok. I didn't have anything to hide. I let them subpoena my TikTok with no opposition. I subpoenaed her Facebook. Initially, there was nothing said. Then a few weeks later, suddenly her attorney comes back and say, "Oh, there's baby pictures that Scofield is trying to keep private." That's a lie. The reason they don't want me into their Facebook, into Scofield's Facebook, is because it has information that proves that what I'm saying is not a lie.
And how do you know that? How do you know that? You're making assertions here. These are conclusory statements. I mean, they're not in pleadings, so you can make conclusory statements all you want on YouTube, but the you claiming that something exists doesn't mean it exists. Doesn't mean it exists. Whereas we know the TikToks exist. Otherwise, you wouldn't have been sued. Now, if you had made your TikToks, if you had accused Professor Scofield of the murders based on things you had seen on her Facebook, then you'd probably be able to get access to her Facebook. But once again, baby pictures of her kids, well, they're just not relevant to this lawsuit. You know, you don't lose all privacy just because you sue someone. That's not how it works.
If I'm not looking in the right camera side, I apologize because I think I'm supposed to look up there. So yeah, there's stuff in her Facebook that obviously makes her guilty of the crimes that I'm saying, gives evidence that she's guilty. So all the entire court case, they tried to play this game, made a lot of accusations of me being a liar, made a lot of false statements about me, and kept talking about me not having evidence. But when it's time for me to get evidence, they're trying to prevent it. So they filed this motion to quash.
It's because you don't have any evidence. Your spiritual acuity isn't evidence. The court, I can't cross examine your tarot cards in court. This isn't South Park. There is no such thing as a suance. I would like to see Sir John Harrington in court. I've got a bone or two to pick with that guy. But like I said, you have to have something more than a conclusory statement, something more than well, that's obviously where the evidence is. They just won't let me get to it. You haven't provided any real evidence that there is anything to go to her Facebook for. I mean, if she were to subpoena any and all Facebook communications between Professor Scofield and the 4 students or the alleged co-conspirator or whatever, or even between Professor Scofield and Brian Koberger, any and all communications between them, you'd probably get those. Well, you'd probably be allowed that discovery. Of course, chances are none of that exists. So you're not going to get anything anyways. But just going overly broad and saying, give me her entire Facebook history, that's abusive. And it's not relevant. Just saying, you know, obviously she's trying to hide her Facebook from me because it proves she's a murderer. Well, do you wouldn't her Facebook friends have noticed that? Wouldn't someone have come forward with that? It doesn't exist.
My subpoena to Facebook. So if there is nothing to hide, why would they go take the time out to file a motion to quash the subpoena to Facebook?
Because Professor Scofield deserves privacy for things that aren't related to this case. That's not a difficult concept.
It's not about a baby picture. They are trying to hide. So here's my issue with the courts. So Meta Platforms did not provide me with the information. They also did not comply. So everybody is talking about I need evidence, but when I'm seeking evidence, there's opposition. Meta Platforms did not respond, which is Facebook, did not comply with the subpoena. They quoted Informations Act, some Communications Act that I looked up and I would have to look up again. So then, and I could maybe I'll do like a more professional video, but I'm just like talking in this video because I haven't been on social media in a while. So I'm gonna just start blogging this process. But anyway, get my thoughts back in line. So they filed this motion to quash. So I finally responded because I was really over this case because the judge is obviously biased. So
I was over this case. You losing motions doesn't mean the judge is biased. You losing motions mean your motions were losers. I mean, if you really believe that you should have succeeded, why not do an interlocutory appeal? Go to the Court of Appeals, go to the Ninth Circuit and say, hey, this judge is unfair. I deserve this discovery because blank. But you can't do that because you don't deserve the discovery. You're not entitled to that.
it's like if the judge is biased and I'm dealing with criminals, first of all, I'm dealing with a murderer who ordered the execution of four students, so a quadruple homicide murderer. And I'm dealing with her attorneys, a criminal attorneys or attorneys willing to commit criminal and civil offenses to protect Scofield. And then now I'm dealing with a biased judge. In addition to being harassed, in addition to being defamed across the media, in addition to all this stuff that I already had going on. Matter of fact, I have at least one, two, three, four, five different people and judges, not judges, five a judge in there too. Companies and judges just defaming me at the same time.
No. But so, first day of my law school orientation, very first day, the law school dean addressing the students said, if you haven't figured out by the second week of class who the class asshole is, it's you. Ashley Guillard needs to, well, maybe no one has ever told her that. If the entire world seems against you, if the entire world disagrees with what you're saying, maybe it's because you're wrong. If all of the attorneys, if all of the judges, if all of the common, the talking heads online or in the media or whatever, myself included, if everyone is telling you you're not entitled to this discovery, maybe it's because you're not entitled to it. It's not a sign of corruption. It's just that you don't understand the rules and the judge does. It's that simple. It's that simple. And I'd like to hear who these five, including a judge, are that are defaming her?
So my entire life has been attacked. My housing situation has been attacked unjustifiably, and this is all stemming from a kind act of me trying to help them find the murder of a former University of Idaho student, and another kind act I did for a family member who also defamed me. That's a whole nother thing. Okay, and then and the people that she was working with defaming me. I'm dealing with a lot of criminals at the same time.
Criminals. Criminals, you say? Defamation isn't criminal. It's a tort. Not a particularly delicious tort, but it's a tort. What crimes are you a victim of? Please inform me.
So anyway, Scofield. Back to that. So because the judge turns around and he grants the motion to quash. So opposition from Meta Platforms, opposition from Scofield and her attorneys, and then opposition from the judge. He grants the motion to quash, which makes
it's not opposition from the judge. The judge granted the motion.
No sense. He then says that I would need to file a motion to compel the documents or to compel Facebook or to request the court to put in an order for Meta Platforms to hand over the information that I requested. But he wrote an order to tell me to motion for an order. When the order that he put through regarding the motion to quash could have been denied, and in the order he could have compelled Facebook, Meta Platforms, for the production of the documents. So what he
did he say that your motion to compel would be granted? There's a difference. He's saying the next step would be a motion to compel. He didn't say it would be granted. He didn't say it would be unopposed.
He did again sided with Scofield, or I feel like he's complicit with Scofield. That's why they wanted to file this case in Idaho, because that's where her power is, that's where her resources and connections are, and that's how they can manipulate the system like they're manipulating this judge.
How much power does she think a history professor carries? I mean, no offense to Professor Scofield. She's my very limited communication with her. She's a lovely person. But she carries no power over the courts. Her power is limited to the history department at the University of Idaho, maybe a little in history academia in general, but I mean, she certainly hired one of the best attorneys in the state of Idaho, the former U.S. attorney for the state of Idaho. I mean, Wendy Olson is an excellent attorney, but you always want home court advantage in litigation. You're not always entitled to it, but it's easier litigating on your home turf. It's easier not having to go to Texas, but it's also all the evidence is in Idaho. The only thing not in Idaho is Ashley Guillard. Now, the problem for her is, number one, she probably established the minimum contacts with the state of Idaho to have granted the Idaho federal court's personal jurisdiction over her. But she also failed to properly object. Not only that, by filing counterclaims in Idaho, she granted the court personal jurisdiction over her. So she can't complain now that she's losing. If you didn't want to litigate in Idaho, that should have been the very first thing you did. instead of going into default and then not, I mean, and as you'll see tomorrow, she's not participating properly in discovery either. So that's going to be a big problem for her. But
So anyway, so the judge grants this motion. So now I have to file a motion to get the order that I need to get Scofield's into Scofield's Facebook. That takes me back to 21 days. They have to respond. They're going to take every bit of that 21 days because they don't want me in her Facebook, because obviously that's where my evidence is. Then I have to respond. Obviously, I have time to respond to to reply to their response. Then the court has time to respond and to both of us, either with an order. That could take a few weeks. So this is pushing me back basically a couple months.
if you're lucky, the case isn't going to last longer than your squabble over Facebook. It's not. I'm going to give you a preview. She has a couple more days, maybe. Let's see. Ooh, it's due today. It is due. Her response to the summary judgment motion is due today, Halloween, 21 days after October 10th, when the summary judgment motion was made. That's going to be fun. Let's see if she gets it in on time. Somehow I have my doubts, but
Give or take. Couple months, give or take. And that's just to receive discovery when we're supposed to have been, like, I issued this order of the subpoena in June. It's October. I'm just now getting a response on the motion to quash. The Meta Platforms has not provided me any information.
What's your hurry?
So in the meantime, I am being defamed. I am being accused of things that I didn't do, while this person who's a dangerous person is just out there putting all of our lives in danger. Not all.
Maybe if Professor Scofield was a dangerous person, putting all our lives in danger, the horror, maybe the Idaho police would be onto her. Maybe if there were any evidence whatsoever besides your tarot cards, she'd have been arrested. She'd be under investigation. The Idaho police, now Idaho may be a little state, population-wise. It may be a little backwards. I often joke, Idaho exists for the sole reason to make Utah look normal by comparison. I really think Idaho's a weird place. But their police, funny enough, they know what they're doing. They know how to investigate crimes a whole hell of a lot better than some random weirdo on TikTok. So if they don't think Professor Scofield is a danger, maybe she's not a danger.
All of ours, especially, my life in danger, my family's life in danger, and obviously the witnesses that are in Moscow, Idaho, putting their lives in danger. She's just getting away with her crimes, and this is just crazy. And the court is complicit. Our attorneys are complicit, and the court is too. I feel like
she's getting away with all her crimes because I'm not getting the discovery that I want, even though I'm not entitled to it, in a civil case. That's not the criminal case. That in reality has absolutely nothing to do with the case against Brian Kohberger.
These people need to be held accountable for their complicit behavior and for helping her. They should be held accountable. The judge, everybody should be, her attorneys especially, they should not be able to practice law after this. But yeah, where is this document? I just got a document too. And let me show y'all from their discovery. From their discovery, they subpoenaed the University of Idaho. And you see, I'm gonna have to do my own subpoenas regarding these institutions because it's very carefully it's very carefully written.
Yeah, it's very carefully written. You want to be exact in what you request, but this looks like it's a response to the discovery request. Guess what? The University of Idaho has lawyers. And guess what? Those lawyers were involved in I don't know if this is a response saying kick rocks, you're not entitled to this discovery request, or here's what we have, these are our records. It's going to the like it's coming from some sort of custodian of records at the University of Idaho, whoever holds those records, but it's going through their attorneys. Their attorneys are looking at it first. Their attorneys are redacting anything that is privileged that they can't give out. Of course, it's very carefully written.
So it says, please produce all documents and communications indicating that Professor Scofield ever taught a class. Excuse me. Ever taught a class at the University of Idaho that was taken by Ethan Chapin, Kaylee Gonzalez, Zana Carnoto.
So when the University of Idaho comes back and says we don't have any evidence of these students taking a class, is that going to be evidence of the University of Idaho covering up the murders?
And I'm sorry for getting the names wrong. Madison Moken or Jack DeCourt. The University of Idaho responds by saying the University of Idaho has no record of the students having taken any classes at the University of Idaho which were taught by Professor Scofield. Who said that? I said she mentored.
The University of Idaho, I mean, the Professor Scofield is trying to show through official records that she had no contact with the students. The way she'd have contact is as their professor. Why would she be mentoring people who are not in her class? Unless, of course, if they're history majors and plan to take an upper level class from her. But I mean, and there very well could be a subsequent question, a subsequent discovery request from Professor Scofield. Please provide, University of Idaho, please provide any communications on University of Idaho systems between Professor Scofield and the students. Because, Professor Scofield might have deleted emails in the ordinary course of business. The University of Idaho might still have those as records. I mean, some of you may know my second law school summer internship was at the SEC, the Securities and Exchange Commission. We were required, even as interns, all of our substantive emails, so like not the morning daily briefings that were sent SEC wide, basically just news briefings, stuff like that. But we had to physically save all of the emails as official records. So the University of Idaho might have something like this that like the professor didn't do. It's just if it's sent on University of Idaho email system, it exists. It's on a server somewhere. That might be the next question. But Ashley Guillard, I didn't ask that. I didn't assert that.
At least one of them. And I said she mentored Kaylee. I didn't say that she taught them in a class. And you don't have to know a student. You don't have to teach a student a class to know them. Then it says, please produce our documents and communication related to any formal investigation the University of Idaho conducted related to the statement made by defendant Ashley Guillard that Professor Scofield had an inappropriate relationship with Kaylee Collins. And then the University of Idaho responds by saying, there is no record of any formal investigation conducted related to the inappropriate relationship with Scofield and Kaylee Gonzalez.
Well, that's just a conspiracy. That's a conspiracy. How dare the university deny it?
Who said anything? I didn't say they did an investigation. They should have.
They're not asking questions that you said. They're trying to prove, look, we didn't have any relationship. We didn't have there was no connection. They don't have to base it on what you said. That they're not limited in their discovery to just your allegations. If it's relevant, if it is relevant or could lead to relevant information, they need to ask it. These are legitimate questions. And the University of Idaho saying we have no such records, that's good information. That is good evidence for Professor Scofield. Ashley doesn't like it because it goes against her fan fiction.
But they didn't. They did. Why was that question asked regarding the discovery? So if you're so innocent, you could just ask the regular question. If Scofield was so innocent, she could say the questions could be any and all communications related to Scofield and all these students. Not specifically if she taught any classes to them. Any and all communication related to inappropriate relationship. Like,
then you can ask those. If you don't like the way that Professor Scofield's very good, very accomplished attorneys ask questions, you send discovery requests to the University of Idaho.
They're specifically asking about a formal investigation. Then the third one says, please produce all documents and communication related to any formal investigation the university conducted related to the statement made by defendant Ashley Guillard that plaintiff Rebecca Scofield was involved with the murder of the students. Then the university responds, the University of Idaho has no record of any formal investigation conducted related to the statements. So basically, they're going to use this saying that there is no evidence, but this is not showing that there is no evidence. This is showing there was no investigation and that she didn't teach the students. Nobody said she taught the students. You don't have to teach them to know them. So these are the type of games that they're playing. If you were so innocent, you wouldn't have to play these type of games.
But where's your evidence that she does know them? Where's your evidence? And besides which, maybe, just maybe, like going back to my email example, maybe Professor Scofield isn't asking the university through discovery for the email because it's in Professor Scofield's custody and control. She can provide the email herself. Ashley would have to ask for the email. Ashley would have to ask the university or Professor Scofield for any and all email communications or telephone communications or text communications between Professor Scofield and the victims. Ashley would have to ask for that. Professor Scofield has it in her possession. So unless she's asking the university for any deleted communications that are backed up on university servers, she doesn't need to ask for those because they're in her custody and control. You ask for discovery for things you don't have. Professor Scofield has her personal communications, if they exist, which I doubt they do.
You would just be innocent. So now this creates more work for me, but I'm also bitter because this is not my job. This is Moscow Police Department, FBI, whoever is doing this case, that's their job.
No. It's not the Moscow Police Department's job to defend you in this defamation action. Their job is to locate, to investigate and support the successful prosecution of the killer of the 4 students. That has not led to Professor Scofield. It led to Brian Kohberger, and he is the one facing trial. It is not their job to defend you, to provide evidence for you, to do anything for you to defend this defamation action. It's specifically your job, Ashley Guillard, to defend yourself in this defamation action. Unless and until you hire a lawyer, in which case it will become their job. It is your job. Not the Moscow, Idaho Police Department, not the Idaho State Police. I think it's Idaho Highway Patrol. It's no one's job but yours. And specifically, it is not Wendy Olson's job to defend you in this. So you may not like the questions she asked the University of Idaho in discovery. You may not like the way she asked those questions, the content of those questions, but she asked those questions because she believed that they led her in the right direction. If you don't think they led in the right direction, it's your job to ask the questions that you want asked. You don't get to sit around hoping that Wendy Olson will do it for you. I really don't like this bitch.
But because they put me in a position that I have to protect myself, now I have to, without paying, use my own money. Matter of fact, that subpoena cost me $225. Where's my money? I have to use my money for that.
Well, maybe, if you don't like spending money to defend yourself, don't defame people. Don't get on the internet and, you can get on the internet all you want and speculate about who committed murders. What you can't do is get on the internet and say, this person is the murderer. I don't have any evidence, but this person is the murderer. If you do that, you're going to have to defend yourself. And, the subpoena cost you money. I'm assuming it's the process server who she sent to serve the subpoena on Meta, on YouTube, or on Facebook. But maybe if you don't like spending money on subpoenas that are quashed, do better. Do better. Send out a subpoena that's not going to get quashed. Learn the rules of discovery. That's where your money is.
I don't want to deal with this. This is not my case. But now I have to deal with this case.
No. The defamation case specifically is your case. You made yourself the defendant. Professor Scofield gave you multiple opportunities to stop defaming her, to retract your statements, She sent you 2 cease and desist letters. You threatened to wipe your ass with them. That's when it became your case. Like I said, the murder case is not her case. She inserted herself into it and got it all wrong. But that's not her case. This, defending herself, is her case. I really do not like her.
Because I have to protect myself. And because they put me in a position where I have to protect myself, and I put myself in this position too by trying overstepping boundaries and trying to help people who did not deserve my help. None of y'all, no people in this world deserve my help, is what I'm saying.
Then
so I
stop.
should not even have done this.
Then stop trying to help. Stop being a clout goblin and inserting yourself into murder investigations that you know nothing about. Just stop. And you'll never have to defend yourself again.
Because I shouldn't have done it, because I feel like it's asking of too much. I was just talking to someone and I just felt like when you over tipping, you know how they say Black women have to do work twice as hard as other people? Like, no, I don't have to work twice as hard. If I already gave you the who, I gave them the murderers. I gave them the motives. I gave them the who, what, when, why, and how. I shouldn't have to also do your investigation. I shouldn't also have to give you evidence. That's overstepping boundaries.
Would you like me to send you a cross to hang yourself on? I mean, Jesus Christ, she's got a persecution complex. And she's the most perfect person ever. She did all of this for us, and we don't deserve it. And ooh, she makes me mad.
I was just talking to people about over tipping and how I just overextend myself so much and I over tip, but then I'm learning that no, over tipping this is negative traits. Over giving is a negative trait, and over tipping is a negative trait. And I told the universe several times, God, I learned my fucking lesson. I don't need to learn any more fucking lessons regarding overextending myself. I'm not doing it no more. So, anyway, that's what I'm dealing with right now.
And it's your
People
fault.
People claim I don't have evidence. But when I try to get evidence, they try to fight me from getting the evidence.
So that means you don't have evidence. I mean, let's examine that statement again. People who claim I don't have evidence, but then try to fight me from getting evidence. So you don't have evidence. You're trying to assert that the evidence exists, but you don't have it. Ergo, you have no evidence. You are making assertions with no evidence that there is evidence. But your assertions are just conclusory statements. They are conclusions of fact that you have drawn with no evidence.
But then also claiming to be innocent. And also claiming that what I'm saying is false. Using the fact that I don't have evidence, but trying to prevent me from getting the evidence. What is all these games being played for if you're so innocent? Why did you have to defame me on news media if you were so innocent?
If you're innocent, why did you have to deny being a killer on news media? If you're innocent, you shouldn't have had to deny my false assertions. It would have just been apparent. Only a guilty person would deny being a killer. This isn't Uno. There is no reverse card. You called her a murderer, so she went on the news to say, I'm not a murderer.
Why did you have to file this frivolous, lying civil complaint? And
because you called her a murderer. You have tarnished her reputation. Because there is no magic eraser that she can go on the internet and scrub all mentions of it and scrub everyone's brain so that no one remembers that you called her a murderer. The only way she can be made whole is through money. How does she get that money? By suing you. You don't you it's not her suing you is not evidence of her being a murderer. It's evidence of her wanting to be made whole because of false accusations that she is a murderer. That's the process. That's the only remedy available, unfortunately.
I feel like people need to serve jail time for filing this civil complaint. That was a lie. Or at least lose their license to practice law. They filed this frivolous civil complaint. They are filing frivolous documents preventing me from getting evidence. They defame me on the news media.
Maybe those documents aren't frivolous since they won the damn motion. Maybe your subpoena is what was frivolous. I mean, when you win the motion, by definition, it wasn't frivolous. It was.
My business has been negatively impacted. My reputation has been negatively impacted. My relationships have been negatively impacted.
Ashley Guillard complaining that her reputation has been negatively impacted. It is mind-boggling. Only one of them went on TikTok accusing the other of heinous crimes. Ashley Guillard is the clout goblin that got on TikTok over 100 times to make statements about Professor Scofield. Professor Scofield did not choose to become a national figure. Ashley Guillard chose Professor Scofield as a national figure to make her a national figure. I mean, if you can't stand the heat, stay out of the kitchen. If you don't want to risk blowback, don't make the statements in the first place.
Impacted. I'm dealing with all these repercussions because I tried to fucking help some motherfuckers who don't deserve to be helped. That's how I feel about it. They didn't deserve my help. They don't deserve my help. I should never have tried to help them, but here we are.
Maybe the Idaho State Police don't want your help. They have said there is no evidence that Professor Scofield has anything to do with this. They'd probably appreciate if you shut the fuck up. So yeah, they don't want your help.
And it's not fun anymore, especially because I mean, I could be focused and mission oriented and big picture oriented and just, do what I need to do to expose her. Because the reason for this, if I think back to when this all began, I did a reading and it said she would not be caught if it wasn't for me. So it was like a choice needed to be made at that moment. If she would not be caught if it wasn't for me.
Oh.
Now, how it happened wasn't very clear. It just said the end, with the end in sight. A lot of times the readings just give you tunnel vision to the end. And it says she would not be caught if it wasn't for me. And it's like,
or maybe tarot isn't real.
wow, she just caused the murder of these four innocent people. And she would not be caught for it if it wasn't for me. Then it's like, okay, do I continue with these videos? Do I continue to try to expose her? Do I accept this case? Do I comply with this civil complaint? Like, I guess at the time, I thought it was the right thing to do, and it made.
I mean, you clearly answered at least one of those wrong because you didn't answer the civil complaint in a timely manner. The judge graciously let you avoid a default judgment, but you were in default.
May have been the right thing to do. It's just that I have so much other stuff that's going on at the same time. Like I'm not just being defamed by one person, Scofield and her attorneys. They not only defame me in a civil complaint, but also on the news media. So my name, my reputation tarnished, relationship, all that. But then I have my housing situation being attacked at the same time. I'm being defamed by that court system. Stuff on my record that I didn't do or didn't cause.
So I don't know anything about her housing situation other than, so you may recall, I believe it was in her motion to set aside the default. One of her reasons was that she was overwhelmed. My mom was sick or someone was sick, and I had this state court case in Texas. So I'm assuming that was her housing situation she was dealing with. But I don't know how she was defamed. Like an eviction isn't defamation. I'm assuming it was an eviction. I don't know. I don't care.
Lies, family members joining in and telling more lies about me, putting those lies on court records. I have a court record out there right now from a family member that she wrote, I didn't pay my rent because my Maserati was repossessed and I had to pay $6,000 to get it. Like that didn't happen.
Show us the record. Show us the court filing. But even still, that's not defamation. Remember, we've discussed multiple times in the coverage of this case the litigation privilege. If it's said in litigation, it's not defamation. It may not be true, but if it's not true, then you're not paying rent, or the allegation that you were not paying rent doesn't matter. And aside from that, okay, that's her statement right there. I had a family member who said I wasn't paying rent because I had to pay $6,000 to get my Maserati out of impound. So there are a couple of statements in there. Statement one, that Ashley Guillard wasn't paying rent. Statement two, she wasn't paying rent because she had to get her Maserati out of impound. Now, if it's an eviction case, let's say her family member was her landlord and the one evicting her, her Maserati situation, whether that's true or not, it's irrelevant. The only question is, was she paying rent? If yes, she might not get evicted. There are other reasons besides unpayment of rent that you can get evicted, but if she's not paying rent, then where her money is going besides rent is irrelevant. If she's not paying rent, she might have some other defense. The requirement that the housing is habitable might not be satisfied. Of course, judging from her TikTok videos from about a year ago, that house looked pretty nice. So it looked at least from the kitchen where she filmed her videos, it looked pretty habitable to me. So
like it just didn't happen. It's just a flat out lie. So I'm dealing with all these people just telling flat out lies about me. Now, lucky for me, on these this other case that I'm dealing with, I can prove that these are lies because it's about me. So I can go through my documents and prove this is a lie, this didn't happen, here's documents, this is my vehicle, this is what's going on with it, this didn't happen, I can prove it because it's me. Like, there's lies about my actual vehicle, my actual situation. So I have evidence for that. So that's lucky for me. But in this
But if you were evicted a year ago over it, what does it matter? Your evidence isn't going to put you back in that house. And you can't sue over for defamation. Like I said, it is privileged. It was in the court filing. So
situation with the students, I have to subpoena and rely on other people to provide me with the information so that I can have the evidence. And for some reason, TikTok just handed my shit over, but Facebook didn't comply. And then they filed this motion. So I'm getting opposition regarding this Scofield situation and getting evidence for that. In which with time, I'll be able to get whatever information that I'll be able to get if the court has jurisdiction and I'm able to do that. If not, and I'm not relying on anybody else to conduct the proper investigations because they've obviously proven themselves to be incompetent.
doing discovery is your job. You, of course, you can't rely on Wendy Olson to do your discovery. And I mean, to call Wendy Olson incompetent, she clearly isn't incompetent. She stopped Facebook from giving her client's entire Facebook history to you. That's not incompetence. That's zealous advocacy. You not liking the questions that Wendy Olson asked the University of Idaho, that's not incompetence. That's Wendy Olson wanting those specific answers to those specific questions. She's not a psychic. She doesn't have to think, well, what does Ashley want me to get from the University of Idaho? No, it's your job to get the information you want from the University of Idaho. I mean, ugh.
And if they wanted to find that, they're too busy trying to put the wrong person in jail. So anyway, if they get it right one day, maybe they'll get it right one day. But because they didn't get it right, I've been negatively impacted, and I'm sure there are witnesses out there whose lives are in danger because they didn't properly investigate these murders. Anyway, that rant is over. I'm gonna post some of these documents, and I'm gonna start doing vlogs on here too because it's a lot of videos, and they just sit up here and lie. I don't look at the whole video, but the stuff that they say on these videos are disgusting, and they just get on here and just disgustingly lie on me, about me, and I'm going to sue. Soon as I can get some of these other things cleared out, I am suing everybody who defamed me on this platform, YouTube.
Does that include me? Are you suing me? Are you suing me? You say you're suing everyone who's defamed you on YouTube. I mean, I haven't defamed you. Like I said, I think I've watched everything that Atozy has done covering this suit. I think I've watched everything Markie has done, and I know she's going to mention them by name. They haven't defamed you. Saying Rebecca Scofield isn't a murderer isn't defaming you. Saying your only evidence is your tarot reading, which isn't admissible evidence for court, that's not defaming you.
Specifically, not suing YouTube, but the people on YouTube it was like Markie, Atozy. They aren't Americans, but I'm sure there's a way for them to be sued for what they've done.
I mean, so Markie is English. He's in England. You're going to, if you think you're going to sue him in Texas, you've got another thing coming. But you're going to have, it's going to be an expensive proposition for you if you try to sue him in England. Now, Atozy, you know, he grew up in Norway. I think he lives in Arizona. I could be wrong. I know he lives in the US. Saying he's not American, well, that I I have a feeling he's got dual citizenship. But that's irrelevant. So you you know, I don't think anyone's established sufficient contacts with the state of Texas, except for Uncivil Law. Uncivil Law lives in Austin, I believe. I know he lives in Texas. He's a lawyer. He's covered you. Only one video that I know of. But hey, you don't even have to do a venue analysis, really. You can just say, hey, this court has jurisdiction. He lives in Texas. Of course, you'd have to do that in Texas state court because you wouldn't have diversity jurisdiction over uncivil law. How about Emily Baker? She lives in Middle Tennessee in the United States. Now, I mean, if you sued me and won, you can't get blood from a stone. You're not getting money from me. Emily, she's got the big subscribers. You gonna go after her? You gonna sue Emily Baker? Sorry, Emily D. Baker? You're gonna have a bad time. But let's carry on.
Everybody who defamed me is getting sued, or they're gonna get letters from my attorney, and I will get an attorney for that because after this I'm taking a break.
Maybe you'd be better served getting an attorney to prevent you from paying out the nose to Professor Scofield than worrying about getting an attorney to sue all these nebulous anyone who defamed me. Now, and besides which, you, as a criminal defendant, you'd have a constitutional right to an attorney. If you can't afford one will be provided for you. With very, 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 very few exceptions, you don't have a constitutional right to an attorney in a civil case. The only one I know of is if your parental rights are going to be terminated, you're guaranteed an attorney if you can't afford one. So, because you're not guaranteed an attorney in a civil case, attorneys don't have to take your case. Now, you say Professor Scofield's attorneys should be disbarred or even imprisoned for taking the case. Any attorney that takes your case, what would that say about them? Because I haven't seen, like I said, I haven't seen all the coverage of you, but I haven't seen any defamation either. I mean, if Professor Scofield lived here in Utah, so the lawsuit was here in Utah, and Professor Scofield took her facts to me, I mean, I wouldn't take the case because I'm not a defamation attorney. It's outside my wheelhouse. But is that a case that I'd feel comfortable taking based on those facts? Absolutely. Absolutely. I would not take Ashley's case based on this set of facts. At least not to sue the YouTubers. You know, defending her in Scofield versus Guillard, yeah, I would. I'd take. It would be expensive. You know, it would have been a $50,000-$60,000 down payment, and that might get her through summary judgment, which that's probably all it's going to take. But, you know, I'd happily represent people getting sued because, you know, they don't choose to be sued. So whether a case is frivolous or not, but I wouldn't put my bar license on the line to represent Ashley Guillard, the plaintiff, because that is frivolous. That's extremely frivolous. So if you find an attorney unscrupulous enough to take the case, it's going to cost you a lot of money. And you're not going to have a lot of money because you're going to owe a lot of money to Professor Scofield before this is all said and done. So when you say, I'm going to get an attorney and sue all of you, I, I'm not scared. Bring it. You, it, you're not going to have an attorney. Besides which, you're not going to have a case anyway. But let's finish this video, the last 30 seconds, and then I will discuss the long promised legal principle that means she's going to lose any case she brings right out the gate. So,
I deserve rest. My attorneys, either they're going to have to issue apologies, or my attorney is going to, whenever I get an attorney, we're going to have a conversation on how I'm going to handle these people who also defame me on YouTube. Because just because you hear something that doesn't mean it's true. So you don't get to just get on the platform and spread misinformation because somebody else told you. You're held liable for your actions. You're held liable for the things that you said. I'm in court because I told the truth. If you see, there's a lot of videos about the murder of the four University of Idaho students and who they think did it, but none of them are in court because nobody was threatened by them. I'm in court because I told the truth, and that person, Scofield, is threatened by me and the things that I said. So anyway,
maybe no one else is in court because you said Professor Scofield is the murderer. Someone else saying, what if this is the murderer? I think this is the murder. That's opinion. That's conjecture. That's not defamation. It's scummy, but you're the one that said this is the murderer. She is the murderer.
I tell the truth. So you can't just say, "Oh, how dare you?" Say somebody get on the internet and say something, you're gonna sue them, but whatever. Yes, I can say what I said because I was telling the truth. They're just spreading misinformation about me. And
how is it misinformation? How is it misinformation to say Ashley Guillard has accused Professor Scofield of being a murderer? There is no physical evidence of Professor Scofield being the murderer. The Idaho and Moscow police say there is no evidence, there is no connection. There is no eyewitness testimony. The only evidence that Ashley Guillard has is her tarot reading, her spiritual acuity and practices, which isn't going to hold up in court. So she defamed Professor Scofield. Saying Professor Scofield is not a murderer isn't defamation. It covering the court filings. That's not defamation. It's bringing attention to her, but it's a factual thing that these court filings exist. That is factual. Her being sued is factual. Her making the TikToks is factual. You'd think a clout goblin like her would like the attention, but she doesn't because it's not positive attention. It's not positive reinforcement.
I'm going to sue them. Anyway, daily rant over. I do have some work to do. So, anyway, guys, I'm okay. Just trying my best to fight through this situation that I'm in and to overcome the obstacles that have been placed before me. Peace.
Yikes. Yikes, yikes, yikes. So let's look at this. And yes, I am going to Wikipedia. Why am I on Wikipedia? Because it's easier. It's there. it's a good resource. Now, it helps that I know what this is. So if Wikipedia were feeding me bullshit, I wouldn't be using it. It's just a good visual, concise way to discuss it. And what's the issue that we're talking about here? It's collateral estoppel. So Atozy, Markie, collateral estoppel is going to be your friend if she ever does end up suing you. I'm not, bear in mind, I'm not your attorney. I don't give legal advice on YouTube. I'm just introducing you to the legal concept of collateral estoppel, which is also known as issue preclusion. Funny enough, this is a concept that Merb discussed, I believe, just last week in discussing the Floyd Wallace lawsuit, where he was trying to drop some of the defendants. And so Merb discussed issue preclusion versus claim preclusion. So let's scroll down. So strategy section here on Wikipedia. Collateral estoppel may be used either defensively or offensively, mutually or non-mutually. So defensively or offensively. It means it can be used by a plaintiff or a defendant. And mutually or non-mutually, meaning between both the same parties, the exact same parties, or one of the parties being different. So you have defensive mutual collateral estoppel, which is used against the plaintiff from, and I should say a little background. This is for subsequent lawsuits. So collateral estoppel, issue preclusion, it cannot be used in Scofield versus Guillard, because that's the first case. That there is no preceding case or first suit, as this says. So it Scofield versus Guillard, for our purposes, is the first suit. So defensive mutual collateral estoppel used against the plaintiff from the first suit regarding issues that were previously litigated against the defendant from the first suit. So this is, because it's mutual, it's the same plaintiff, same defendant, and you basically, if the first suit had a decision on the merits on that issue, it can't be relitigated. Then you have defensive non-mutual collateral estoppel. That is our friend for today. So used by a new defendant in a subsequent suit who wants to assert a final judgment on an issue against the plaintiff from the first suit. So what does that mean? What does that mean? So let's say that Ashley Guillard has lost Scofield versus Guillard. The court has issued a final judgment on the merits saying Ashley Guillard defamed Professor Scofield by calling her a murderer and by calling her, saying she had an affair with one of the students, victims. The court rules that was defamation, that Ashley Guillard had no evidence to make such an assertion. She based it entirely on her tarot reading, which is reckless. It's a reckless disregard for the truth on Ashley Gillard's part. She loses in any subsequent court proceedings. That next court has to basically recognize that judgment. It has to say Ashley Guillard defamed Professor Scofield. She had no facts to make these assertions. So if Ashley Guillard sues me, Guillard versus Joe, for defaming her by saying whatever, talking about this case, my first movement, I mean, we're assuming she sues me in the right court. If she sues me in Texas, I'm going to move to dismiss for lack of personal jurisdiction. But let's say she sues me here in Utah. Just take that analysis out. I'm going to do a 12b6 motion to dismiss for failure to state a claim upon which relief can be granted. And why is there no claim upon which relief can be granted? Because of defensive non-mutual collateral estoppel. She can't assert that I defamed her by saying she defamed Professor Scofield because the court has already ruled she did. It's that simple. Now, like I said at the very beginning of the video, go back an hour and 40 minutes. I said, this defense isn't ready yet. It's still in the oven. But Ashley's response, her opposition to the motion for partial summary judgment is due today, Halloween. Give a little more time for Professor Scofield to do a reply if she wants. She probably doesn't need to. And and then we're just waiting for the court to make its ruling. And based on where things are, I'll explain it all in the next couple days, because we're sticking with this until I've finished the docket, until we're caught up. This is what we're doing this week. Professor Scofield's about to win. There no ifs, ands, or buts. She's about to win, unless the court really, really, really goes easy on Ashley for her pro se status, but it's not going to do it. So basically, let's look at offensive non-mutual collateral estoppel, because it has some factors listed here from the Park Lane Hosiery versus Shore lawsuit. So offensive non-mutual collateral estoppel is used by a new plaintiff in a subsequent suit who wants to assert a final judgment on an issue against the defendant from the first suit. And so this would be if, let's say, the victim's estate in Idaho, the four murder victims' estates, their families, if they wanted to sue Ashley Guillard for unintentional infliction of emotional distress or defamation, if Kaylee's family especially wanted to sue for defamation, or even I don't know his name, but the supposed accomplice, the person that Ashley alleges Professor Scofield hired to carry out the murders. Let's say he wants to sue Ashley. That's offensive because he is suing. He's a new plaintiff suing the defendant from the first suit, Ashley. And he wants to preclude basically Ashley from being able to argue that Professor Scofield was the murderer, or that Professor Scofield hired this third party to commit the murders. If she can't do that, that makes it a whole lot easier for him to win his lawsuit. There's a little bit more that he'd have to prove, but not being able to argue about that specific issue is basically is what he wants. Claim preclusion is if it's the entire thing. So, well, we won't get into claim preclusion, but so for offensive non-mutual collateral estoppel, the U.S. courts look at a couple factors, which it's going to look at as well for defensive non-mutual collateral estoppel. So could the party trying to assert collateral estoppel have intervened in the earlier suit? So, like, could the alleged accomplice have intervened in Scofield versus Guillard? Could he have filed a motion to intervene to be a co-plaintiff and sue her at the same time? Well, so flipping that, it's not a specific factor, but could I have intervened? No, because it's defensive. She's not suing me until she sues me. But did the defendant? So did the defendant have incentive to litigate the first action? So obviously, I don't have an incentive to litigate the first action because that's offensive collateral estoppel. But defensive. So did Ashley? Like I said, this isn't specifically a factor because Park Lane is offensive, Park Lane hosiery. But did Ashley have incentive to litigate the first action? Of course she does. She has incentive to defend herself. It's not did she do a good job defending herself. It's does she have the incentive to? Are there multiple prior inconsistent judgments? That's not going to be a big worry here. And are there any procedural opportunities available to defendant in the second suit that were not available in the first suit? Not that I know of. So let's think about what this is. Let's give some examples outside of this. So I hate to keep going back to Johnny Depp versus Amber Heard, but you may remember that Amber Heard tried to stop the case from the start. Her lawyers argued consistently that, hey, look, this case has already been litigated in England. You can't sue us in Virginia. And, the English courts have already determined that Johnny's a batterer. So you can't sue us now. That's precluded. That's it. So that would be defensive mutual collateral estoppel. So Amber Heard using against the plaintiff in the first suit. So against Johnny, because Johnny was the plaintiff versus the son that were previously litigated. Oh, sorry, no, this would be defensive non-mutual collateral estoppel because Amber specifically was not a defendant in the UK case. She was a witness. She was not. She wasn't a party. She was not the defendant. So it's non-mutual. This is complicated stuff. But the reason the Virginia case went through is because it wasn't the same claim. It wasn't the same claim. The UK case was Johnny Depp versus the Sun. I believe it was the Sun's parent company, but we'll just say the Sun. And it wasn't about whether Johnny was a batterer. So the court making the statement that it finds he is a batterer, that's irrelevant. The question was the Sun reckless in reprinting Amber's statement? So it wasn't, is Amber's statement true? It was, was the Sun recklessly, was it reckless printing her statement? And the UK court basically found that the Sun could reasonably rely on Amber's statement. So that's what the case was. Whereas the case in Virginia was if Johnny battered Amber. So those are different issues. So that issue was not precluded, so the Virginia trial could proceed. Whereas if Ashley sues me, the issue of her defaming Professor Scofield, her having no evidence, no real evidence that Professor Scofield is a murderer, that's precluded, or at least it will be very soon. But let's do another example. This is non-mutual. So let's look at O.J. Simpson. O.J. Simpson was found not guilty of murdering Nicole Brown Simpson and Ron Goldman. After that, he was sued by the estates of Nicole and Ron. OJ might want to argue, hey, look, I was found not guilty. But number one, it's a different claim. It's one is murder, the other is wrongful death, a civil claim. But it's also, they have different evidence standards. So if there are different evidence standards, collateral estoppel probably isn't going to work. It's not going to be available because he was found not guilty at a reasonable doubt standard, but he could still be responsible at a preponderance standard. Now, if he had been found guilty at the reasonable doubt standard, the much higher standard, then he's probably also responsible at the preponderance standard. But let's go to New York right now. Let's go to New York right now. We have Sam Bankman-Fried on trial, but this is a criminal trial. This is a criminal trial. Let's say things were backwards, and let's say the SEC case went first, and he was found to have violated the securities laws. That's civil, so that's preponderance standard. And he's found responsible. The government can't then go and say, hey, look, he's guilty of criminal securities fraud because he was found responsible at the civil. Well, no, he was found to be more likely than not. He hasn't been found beyond reasonable doubt guilty. So that's a different standard. Whereas he's been charged civilly by both the SEC and the CFTC. Separate cases. The SEC for securities fraud, the CFTC for commodities fraud. If he's found responsible in one, it's not the same issue because even though they're the same behavior, a security isn't necessarily a commodity, so the jury still has to find one way or the other. But so this, I'm trying to illustrate, this isn't often an issue. You get what I did there? Issue preclusion isn't usually an issue, or at least it's not often available. But if Ashley tries to sue me, hey, it's great news for me. It's great news for Atozy, for Markie, for Emily D. Baker. Any coverage that I have seen. I'm not saying no one has defamed her, but based on what I've seen, she's going to have a really hard time. A really hard time. So, with all that, I'm going to leave it here. I'll be back tomorrow discussing. Let's take a look at the docket. Let's see. Let's see. Okay. So I have not covered the motion to quash the subpoenas. So I need to do that. I have done the motion to dismiss the counterclaims. This is the reply to that. I believe I've done the memorandum granting the motion to dismiss the counterclaims. I don't think I've done this. The first motion to dismiss complaint by Ashley Guillard, so I need to do that. So response to the motion to dismiss, response to motion to quash subpoena, reply on the motion to quash. Oh. So our old friend, the motion for sanctions, which I don't think I've done, or I think I have. Then the newest is motion for partial summary judgment. There was some crazy in there that either way, that's kind of the stuff I'm going to do over the next couple days. You can see there's a lot of stuff that needs to be covered. And I think this first motion to dismiss is the crazy document that I'm thinking of. It's just the title I thought was something different, but it's unhinged. It's unhinged if I remember right. So either way, that's what we're going to do. I'm going to leave it for tonight. Happy Halloween. Be safe trick-or-treating. If you're not trick-or-treating, be safe if you go out. Watch out for trick-or-treaters. And do all the YouTube-y stuff. Like, share, subscribe. Bribe your friends to do the same. And Ashley, just try me, bitch.